Are you Caleb LaFleur?
Yes, ma'am.
This is 26 DCCR 0039. Mr. LaFleur is charged with theft of property. First degree felony, November 14th of 2025. And what is the announcement?
So Your Honor, if we could get one more reset, it's indicted as a first degree, stating that the value is 300,000 or more. It appears in the reports, it may be 30,000. So that's a drastic difference of
Sure.
what this could potentially be. So if we could get a reset to make sure that that is accurate, and if so, then obviously that indictment may need to be amended.
And
The state would like the opportunity to do a little investigation. Yeah, Ms. Holmes is correct. In the offense report, there's a $30,000 claim. And I don't know if the extra zero was a typo that just fell down the line, but I would like an opportunity to investigate the actual amount of damages.
I'm just looking, what is the current bond set at? And that's probably,
Yes, and what is your bond?
100,000.
100,000.
do you have any other holds on you
I'm different partnership.
from Calcasieu Parish? They have a hold on you?
Yes, ma'am.
Okay, so let's just do a normal, I'll do a normal reset.
Okay.
Now, if something happens and you guys figure out that it is 30 and there is an amendment to the indictment, let me know.
Okay.
Because I think it would make some sense, depending on other criminal history, maybe not, to at least look at that bond
Yes, ma'am.
that's set in this case, okay?
Okay.
All right, you can go back with the bailiff. And then you've got Donnie Smith.
If we could hold that, it's gonna be a plea.
Sure, I'll hold that. We'll hold Donnie Smith. I'm gonna hold that one. Looks like you've got Darren Tamble ready.
Yes. Ashley.
And Mr. Coleman on Darren Tamble.
I've got it.
Do you?
Well, it's different. Mr. Coleman to take care of something.
Oh, yes,
Oh,
okay. That's right. All right, sir, are you Darren at Tamble?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor. And we're going on count one. I don't,
Oh.
think, is there multiple counts on it?
There are.
It's
Just
count
count.
one.
Okay, let me get that. Okay, getting there. Mr. Tamble, in cause number 25 DCCR 1802, the state has elected to proceed on count one only. It alleges you committed the third degree felony offense of assault on hospital personnel on hospital property, October 15th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Tamble is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of assault on a hospital personnel in count 1, a third degree felony. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed. So you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Right? Thank you, sir. You can go back with bailiff. Thank you, Ms. Holmes.
Thank you very much, Your Honor.
Yes, sir. Thank you. Let's see, Ms. Holmes, you have John Dre Willis. It's a
Yeah, ma'am.
sentencing.
Okay. This one was the one with the Louisiana case.
Yeah, Joe, find out
So-
some, let's get him on.
Okay.
Good morning, you're John Dre Willis.
Mhm.
And so we were here before for sentencing. Mr. Willis had pled guilty to burglary of a habitation. There was a question about whether or not there was a murder charge pending or coming over in Calcasieu Parish. Charles? Lafayette, sorry. And so what did you guys find out?
Okay, so I spoke with the detective out there. He referred me to the prosecutor. Prosecutor said that there is a co-defendant. His case was sent to the grand jury. The grand jury, they don't call it no bill out there. I don't know what they call it. They no billed him on the murder, but they sent in a suggestion for manslaughter. So
On the
on the
co-defendant.
co-defendant.
Okay,
So the prosecutor told me that it's possible that Mr. Willis' case may go to the grand jury as a manslaughter, but he doesn't know yet. And he said they don't know until Mr. Willis gets to Louisiana. So there hasn't been anything filed on him.
okay.
Judge, I left a message for same District Attorney Chris Landry on February 24th after we recessed from our last docket. I called back and spoke with his assistant who was going to give him another message. And I made multiple attempts yesterday to reach him and wasn't able to reach anybody at that number where I had previously reached them. So I made every attempt I could to let him know. I filled in his paralegal about the situation we had and said, hey, heads up, if you guys want to hold or you need a 10-day marker or something, it'll be from next Tuesday, meaning today. So
Right.
those are the efforts I made. And I would suggest that out of fairness to the defendant, we, if the court is inclined, we go along with the original plea of deferred. If
Sure.
they want to use it later, I'm happy to share my files information with them, but I don't think we should punish him with a conviction for something just because that may or may not be out there.
All right, I agree.
And also, Judge, I'm sorry. to
Sure.
interrupt, just so that the court can recall, this is the one where the complainant went back and forth on wanting to prosecute. She did not. She came to court. She got a little jittery. She changed her mind. She waffled back and forth a few times, which was the reason for it all.
Okay, thank you, Ms. Malvino. And thank you, Ms. Holmes, for making those calls as well. Okay, so what I'll do, Mr. Willis, today is go ahead and go forward with sentencing just the way this was all set up. If something happens when you get over to Lafayette and you're indicted or convicted, obviously we'll know where you are. If you, as soon as you're released, if they get a hold on you and take you straight from here, then when you are released, the first thing you need to do is contact our probation office.
Okay.
So whenever that is, all right? And if for some reason there's a conviction over there or something and you get some type of prison time, then you can write Ms. Holmes or get in touch with her or the court. And there's probably some ways that we can take care of this at the same time so that you're not doing some time and also on probation. Okay, but we'll deal with that when and if it happens.
Okay.
All right, so then in cause number 25, DCCR 1048, I'm going to find that you, and we've already gone over the pre-sentence report and everything. So I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You order to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, then this is an excellent opportunity, especially if nothing comes out of whatever happened over in Lafayette, because you do not have a felony conviction on your record. And if you successfully complete this probation, at the end, the case is dismissed. You'll never have the felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty. So you would become a convicted felon and you could be sent to prison for anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand? And I'm assuming there is a no contact.
Colette Richard.
What's the name?
Colette Richard.
Colette Richard. And so you're not to have any contact or communication with Colette Richard. And I understand that she's gone back and forth and y'all have gone back and forth. But unless you have my permission, which could happen if you get out and you're on probation and you're doing well, and she probably takes an options class or something like that. If y'all are planning some type of relationship, you're not, so we don't have to talk about that. Then don't contact or communicate her. If she tries to contact or communicate with you, don't reply, okay? Because she won't go to prison, you will, right? All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir. Yeah. Let's see, this is Miss French on William Jones. Good morning, sir. Are you William Leroy Jones? Mr. Jones, in cause number 25 DCCR 1627, you're charged with the state jail felony offense of theft with previous theft convictions from August 3rd of 2025. The indictment alleges you were previously convicted of theft June 1st of 2023 in 2 cases. After that was final, November 16th of 2023. And then after that, August 6th of 2024, and then 2 cases on August 15th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand? And then in cause number 25 DCCR 1628, you're also charged with theft of property with previous convictions. Offense date in this case is from August 2nd of 2025. Those same prior convictions are applicable and listed. Same punishment range if you're found guilty. Do you understand? And cause number 25 DCCR 1629, also charged with theft of property with previous convictions from August 9th of 2025. Same prior offenses, convictions are listed. Again, means if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years. You understand?
Yes, ma'am.
And then finally, in cause number 25 DCCR 1630, you're also charged with theft of property with previous convictions. This is from August 15th of 2025. Again, it lists the same prior convictions, makes it the same punishment range between 6 months and up to 2 years. Do you understand? Excuse me. In all of those cases, I have here on the tablet some documents called plea bargain rejections that you signed with Mr. Lewis. This shows that the district attorney's office has made offers if you wanted to enter pleas of guilty. And it looks like for 20 months in the state jail, and that would run concurrently in all the cases.
Yes, ma'am.
You have every right to reject that offer and have all 4 of your cases tried to a jury. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am, I do.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am, I do.
All right, we'll get that done. Ms. French, is there any reason to believe that that offer would be reduced?
Mr. Lewis has spoken with me this morning about a possible issue for me to consider. I don't know that that's going to move the needle for me, but it's a possibility.
So what I'll do then, I would like, is that, how long will it take you to kind of look at that? And I don't want to put it on the trial docket. If there's a potential, if we could do it as soon as that's over. So let's reset it for 2
2
weeks.
weeks.
Okay.
If there's some change in offer, then I've already, if you want to. Okay, just leave them there. I've sent them to you and we can always write on it if it changes to a different offer. Otherwise, we'll go through that process of setting it for trial on that day. All right, so we'll reset it for 2 weeks.
Thank
Thank
you.
you.
I'll go speak with Mr. Child.
Okay, thank you.